Hey everybody, welcome to week 6. It is day 53 on the self-quarantine count. That's starting to feel like a lot of days, and it's starting to look like it's hard to tell when that's going to be over. Still don't know whether in fact we're going to be doing fall term in live classrooms at PSU. I think they're leaning in that direction. It's going to be interesting, probably bigger classrooms, some kind of social distancing guidelines. But yeah, here we are in my dining room. Today, week 6, so we're now in the second half of the course. We've gotten over the midpoint and it's going to go really quickly from here. I know that some of you might be having challenges with time management and workload and just, exercising the necessary will to do the things that you now have to decide to do because they don't just come to you. I've had that today. I've spent about the last hour and a half getting myself to do this lecture. Whereas if it was a class, I would have to just be in the classroom at 8 o'clock in the morning on Tuesday morning, and then I would be doing it. There's no will to exert there except the standard will of like be responsible. Now there's the additional level of you have to not only be responsible, then you have to actually make yourself do something when there's no specific deadline or people watching over you. So I understand the challenges of that, and I hope that you're able to manage those challenges, and I definitely will be more understanding and forgiving than I would under normal circumstances if there are challenges that are getting you to make it difficult for you to do your coursework, even just to watch these videos or to listen to the podcast version of these lectures could be a challenging thing. All right, so just know that that's something that we're all experiencing, and you're not alone, and I'm sensitive to it, and I appreciate people who have challenges and reach out to me, and we'll work stuff out. Today's class is the second in this part of the class where what we're doing is we're going through sort of the politics of political reform, how to get across the finish line, what it takes. And last time I talked about amending a constitution and what the different dynamics that play out in different types of situations. If you're trying to amend a state constitution, it depends on what state you're in, and it depends on the balance between responsiveness and stability that's built into that constitution. If you're trying to amend the U.S. Constitution, really that's the tallest hill to climb. It is the biggest multi-layer supermajority, double supermajority task. Today we're going to look at judicial reform, which is, as I've indicated, and it's not just indicated but said straight out, is in some ways the easiest pathway to achieving reform. It is also the narrowest in the sense that not every political reform can be achieved through the judicial avenue. There needs to be a constitutional question involved, and there needs to be an avenue, an argument through the Constitution and through the body of the judicial rulings that have been built up around the Constitution that makes it possible. And then there needs to be a court that is willing to accept that version of constitutional interpretation. Today's reading, Baker versus Carr, which I will get to at the end of the lecture, or in the final portion of the lecture, is an example of a political reform that was achievable through the judicial avenue, but it might not have been. And one of the challenges of changing something important, and political reform is almost always an important change. It's not usually some kind of incremental, just like, okay, we'll monkey with this little thing, the way that statutory change can be. Usually it's something important to set a new precedent, and precedent will be a theme in today's class an awful lot, and I'll talk a lot about it, but to set a new precedent or to even move established precedent in a different direction is very challenging. And the podcast episode for today, The Political Thicket, gives you an indication of some of the sort of psychological dimensions of that difficulty. There are also, essentially political and judicial difficulties in adding a new way of interpreting the Constitution, adding a new set of judicial doctrine that will pave the way, or either achieve or pave the way for some kind of political reform. Now, it does happen, and judicial reform, the judicial avenue as a way of achieving political reform is a successful path. Now, much like statutory change, there are all kinds of changes that can happen through the judicial avenue that aren't political reform. There are, in fact, most cases don't deal with questions about the fundamental nature of our political system the way political reform does. So there, any case, for example, about the Affordable Care Act, adjudicating whether or not the terms of that particular act of Congress are aligned with constitutional principles, that's about healthcare reform. And you can achieve healthcare reform, you can achieve immigration reform, you can achieve all kinds of reform through the judicial avenue. So it is not that the judiciary is a political reform route only. It touches on all the areas of reform. But one of those areas is political reform, and I'll focus on that. But pretty much everything I talk about today is going to apply across the board to any kind of reform effort that might act through the courts. If you're looking to expand civil rights, if you're looking to reduce the government's role in some kind of regulation, those are kinds of reform that the judiciary is an avenue that you can achieve those kinds of reform through. So, how does it happen? Well, first just want to contrast judicial versus amending a constitution. One of the things about amending a constitution is that there is an established process that is written into the Constitution itself. It's actually a formalized process, and that whatever that process looks like, whatever level of majority or supermajority, whether it's a single layer or a double layer, whether there are 3 or 4 different methods available in a Constitution, they're all written in the Constitution, and it is therefore a very formalized route. It's there are specific thresholds that are established, and it's known and very mechanical what it takes to cross that threshold. It's not debatable that if you have 55% of the senators vote for a constitutional amendment, it's not debatable that that actually doesn't reach the threshold. It's also not debatable whether or not there are other ways of getting an amendment into the Constitution than the 2 avenues listed in the U.S. Constitution. It's very formalized. And the formalization in an amendment process it strikes a balance between responsiveness and stability. And I talked about that quite at length in the last lecture, so I won't go into it much more. But just know that that's what it is. Essentially, it's a philosophical balancing. It's a trade-off that is then formalized in a specific set of procedures. The judicial avenue of reform is not like that. The judicial avenue of reform is actually based on a set of traditional practices and those traditional practices operate through an institutional framework that is established formally in the Constitution and that is then further elaborated because the Constitution doesn't say a whole lot about what the federal judiciary looks like. It doesn't say anything about what the state judiciaries look like. It is then further elaborated by statutory law. So the reason why we have 9 members of the Supreme Court is not because the U.S. Constitution says that. The U.S. Constitution refers to a Supreme Court and other lesser courts as Congress determines, and that's pretty much it. And then there's a short listing of what powers the court exercises. None of which actually are the power that is required to achieve any kind of reform through the judiciary, which is judicial review. The power of judicial review is the ability to declare things null and void, to void acts of government. Whether that act be a law passed by a state legislature or by Congress, whether that act be an executive order, whether that act be an executive branch regulation, whether that act be something that is done by a government commission, any act of government can be voided through the power of judicial review. That power is not one of the powers that is listed in the U.S. Constitution as a power of the federal judiciary. It is, in fact, a traditional practice that was established through an important precedent, Marbury versus Madison in 1803, and has been essentially strengthened. It was strengthened throughout the ensuing decades when Chief Justice John Marshall, who wrote the majority opinion in Marbury versus Madison and pushed for judicial review to actually be an implied power of the judiciary and to make this a traditional practice. He deeply embedded it over his 35 years as Chief Justice in the Supreme Court. And by the middle of the 19th century, it was well established and accepted universally that judicial review was a power of the judiciary. Even the most hardcore originalists on the court, and I'll talk about what originalists are if you don't already know later in this lecture, even those hardcore people who say that the Constitution ought to be narrowly interpreted, not expansively, you don't look for implications between the lines, you read the plain text of the Constitution, and when there are questions, you refer to what the original authors most likely intended. The original authors of the U.S. Constitution did not intend for judicial review to be an obvious, explicit power because it isn't in there. You have to read between the lines. But even the most hardcore originalist doesn't deny that judicial review is one of the powers of the Supreme Court. If you're Clarence Thomas or Anton Scalia, and Anton Scalia is no longer alive, but he was one of the most sort of consistent and hardcore originalists. And you don't say, well, we would love to strike down this law that's at issue in this case before us, but the U.S. Constitution doesn't grant us this power. It was not originally intended to because the authors of the Article 3 didn't include it explicitly. It took this set of traditional practices that built up over a case precedent to give this power to us. And so we don't think we actually get to do this. There's no matter how narrowly you want to interpret the Constitution, no matter how much you want to go with the founders' intent, giving away the power of judicial review is essentially rendering the entire judiciary almost entirely toothless. The Supreme Court would still get to rule in cases and they would get to decide the winner and loser, but everything would be on a case-by-case basis. And so the role that the judiciary would play in any kind of reform effort would be extremely limited. If there was a case about an abortion law that came from Texas, the only implication of the court ruling in that case would apply to Texas. It wouldn't apply to any other states. It wouldn't apply to other laws that are similar. And it wouldn't even necessarily null and void that law. It would just give somebody who was a loser before, turn them potentially into a winner. So judicial review is not listed in the U.S. Constitution. It's not an explicit power. It is a traditional practice. The fact that we have 9 justices is statutory it's part of the statutory framework. It's also become kind of traditional because even though you could change it with a simple law, it doesn't even take any kind of supermajority. It does not take a constitutional amendment. Congress, with simple majority in the House and the Senate, could pass that law, changing the size of the Supreme Court to 15, reducing it to 7. Though if you reduce it to 7, you couldn't kick people off, but you could say, well, the next 2 retirees don't get replaced. If Donald Trump gets reelected and the Democrats take control of both houses of Congress, they could actually say, we're reducing the size of the Supreme Court to 7. So the next 2 retirements or deaths don't get filled. They could deny him that. That's, in fact, the last time there was a kind of a changing nature of the court size was during the Civil War and Reconstruction, and the Republicans, the radical Republicans in control of Congress, didn't want Andrew Johnson to be able to appoint new people to the Supreme Court, so they reduced the size of the court from 10 back down to 9, where it had been for a long time, to deny him an appointment. Congress, if they could, of course, they would have to be able to override a presidential veto because no president's going to sign into law a bill taking away one of their most important and cherished powers, the ability to appoint people to the Supreme Court. But Congress could, either with the signature of the president, which is unlikely, or with a veto override, 2/3 in both houses, could, so a supermajority would really be required, could change the size of the court and reduce it to 7. And then wait until there's a Democratic president and then raise it up to 11 or raise it to 9 and then basically give that incoming president 2 new appointments. All of that is completely constitutionally legitimate. And there's a clear and simple, though simple, not necessarily easy, but simple statutory path to doing that. It's just a simple law. It doesn't have to be any kind of complex thing. It doesn't have to be a constitutional amendment. Why is that almost unthinkable? Because the traditional practice is such that the Supreme Court is 9, and we've kind of come to accept that. The traditional practice that is not actually embedded in statutory law is that the court exercises this kind of grand power to be the final word and to declare void any act of government that comes under its jurisdiction. Now, not any act of government at all, and it's important to say that comes under its jurisdiction, because judicial review only works when there is a constitutional issue at hand, as I said before. So you can void acts of government based on the Constitution. And there is a set of sort of traditional practices embedded within the exercise of judicial review that does keep place a boundary, not a statutory or constitutional, but a traditional boundary around how big this sphere of judicial review can be. And one of the concepts is justiciability, right? Is a question justiciable? There are plenty of questions that are not justiciable. Term limits is not justiciable. If you want to limit the terms of members of the Senate to 3 terms, 18 years maximum, or members of the House of Representatives to 6 terms, 12 years maximum, whatever it might be, that's not a justiciable question. And so justiciability, I'll put that up here. Justiciability is the boundary around this particular avenue of reform. And what questions are and aren't justiciable? There's black and white, and then there's gray, as there is with almost everything. Some questions are clearly not justiciable. Other questions clearly are. And then some fall in that gray area where it's are they or are they not. Baker versus Carr is a perfect example of a case that fell right in that gray area. And that was actually one of the reasons why it was so psychologically harrowing for the justices on the court, and why it was so problematic for the reformers to get a victory, even though it seemed what Tennessee was doing, what the state of Tennessee was doing, seemed based on any even primitive, brutal, simple view of what democracy should be. They were violating basic democratic norms of political equality by having a scheme of representation that allowed certain people's votes to weigh way more than other people's votes. It wasn't a question of whether or not what Tennessee was doing was legitimate democratically. The question was, is it a justiciable question, or is it a political question? And the court has always maintained that boundary, but of course, different justices, different scholars, different political reformers have had different opinions on whether a specific question is or is not justiciable. A decent chunk of justices in Baker versus Carr were leaning towards that this is not a justiciable question. This is a question that is addressed. Districting and representational schemes is traditionally addressed through the political system. It's a political question. So justiciability versus political questions gives us the boundary of judicial reform. All of this is a traditional practice, and really the entirety of the way the judiciary functions is saturated with traditional practices. Now, there are also plenty of statutory and a handful of constitutional boundaries that are formal and written down that are clear. And you know, one of the things that Congress does, and state legislatures do this too, is they establish rules of evidence, they establish court procedures, they establish the boundaries of judicial districts, they establish how many appellate courts there are, all of this stuff. And what we have in our judicial system, we have a 3-layer system where we have the trial courts here, which are the district courts, we have the appellate courts here, which are the circuit courts, and we have the Supreme Court at the top. This triple-layered system, with most questions arriving at the district level, but some questions arriving at the circuit court level, that's almost entirely, I mean, this very pyramidal structure is decided by statute. This has been determined. If for example, Congress determined that in order to ease the workload of the Supreme Court, or in order to make sure that the questions that are answered at the circuit court level are actually filtered one more time before they get to the Supreme Court, Congress could add a 4th level. They could add another appellate court above the circuit court, or they could add another appellate level below the circuit court. Where we have 13 circuits and there's 105 district courts, Congress could create 40 preliminary appellate courts that would then reduce the workload of the circuit courts. Now, one of the reasons why that would be important is that there are thousands of cases here, or tens of thousands of cases here each year. There are thousands of cases here, and then there are about 50 to 100 cases that get to the Supreme Court. And in terms of the traditional practice, the ruling of the last court that rules is the one that stands. So for all of the thousands of circuit court cases that don't make it to the Supreme Court, the circuit court is the final word on what the Constitution means and what the law of the land will be in this particular case. So that, and again, that's a traditional practice. In order maybe to have the circuit court be a filter that deals with, say, 200 cases a year so that most of those could go on to the Supreme Court, there could be a lower level added. Now, that would actually be a form of political reform that would go through the statutory realm, which is to change the functioning of our political system. Because the judicial branch is obviously one of the three branches. It's part of our democratic system. So that would be changing the way the judiciary functions is a form of political reform that, for the most part, would have to go through, or not for the most part, in this way would have to go through the statutory realm. There are, however, because so much of what goes on in this pyramid is established by statute, the existence of the Supreme Court is mentioned in the Constitution, and there are some specific powers granted to the Supreme Court. What also happens is that because this is both a constitutional and statutory structure, and constitutional and statutory questions come up for judicial review, a lot of the way the court works, the traditional practices, are built up internally through court rulings, right? What the act of judicial review actually does is it creates a court ruling that is essentially policy. The ability to void an act of government or not void it is a policy-making power. So the judiciary is, judges are often criticized for being judicial activists. Like, they're too active, they get too involved in policy-making. The very act of making court rulings that use judicial review, instead of just rule on case-by-case basis, is an activist role. Now, how activist you are is really more a question of where you put the boundaries, right? The activist label is typically placed on judges who, one, are more likely to see justiciability where other people might see a political question, and two, where judges are more likely to be aggressive about using a court ruling to make, instead of a pretty narrow policy, a broader policy. And I'll talk about judicial activism a little bit later. But the judicial system is a policy-making system, but it's a policy-making system with a boundary. Congress has boundaries on its policy-making power as well, and those boundaries are constitutional, right? Article 1 lists the express powers and the reserved powers of the states, and those provide specific written-down boundaries. The Constitution doesn't have a boundary. The concept of justiciability is not in the Constitution. It's implied, it's not explicit. The concept of a question that's a political question that the courts can't and shouldn't touch is also not written into the Constitution. Again, it's implied. Congress has explicit powers, and then, of course, it also has implied powers, but it's way more constitutionally bound what goes on in the legislative branch. The court rulings and policies themselves often determine the operation, the rules and procedures of the judicial branch itself. And I'll give just one example, and there are innumerable examples, but one example, a very influential and important example is the case of Mapp versus Ohio. And Mapp versus Ohio is a case where the Supreme Court, ruling on whether or not a particular type of search was protected, was acceptable or unacceptable according to the terms of the Fourth Amendment's search warrant requirement. The details of the case are not important for our purposes. What is important is that in making this ruling, and I'm going to put over here, a court ruling has three features to it. The first feature is the winner. Who wins this particular case? Okay. The second feature is the the reasoning. Why does this party win instead of the other party? And there are two features of the reasoning. One is precedent, and I'll talk about precedent an awful lot today, and the second one is constitutional interpretation. In the case of Mapp versus Ohio, the winner is Mapp. Mapp was a person who was arrested after and convicted after having a search performed. I think it was on his car. I can't remember the specifics of it. But his lawyers challenged the search and said there was no search warrant, and it violated the Fourth Amendment's requirement that you have a search warrant or that you have probable cause. And the court agreed and threw out the conviction because the evidence that was obtained in violation of the Fourth Amendment was shown to the jury, and the jury saw it and said, yeah, you're guilty because there's the hard evidence. It was actually a simple case. The question was not about whether or not Mapp did the crime or not. The question was, could this evidence, which was obtained in violation of the Fourth Amendment, be shown to a jury? And when the court said the winner is Mapp, they could have just said Mapp goes free, right? If there'd been no judicial review, that's what would have happened. That's what a case-by-case ruling looks like. It's like, okay, Mapp, you go free. And then next time we hear a case that comes up that looks like this, we'll set that person free. But the way that judicial review works is that judicial review then results in the third part, which is that we get principles and standards and doctrines that emerge from these rulings. And this is really where we have the policy-making power. That's what this is. In Mapp versus Ohio, the court didn't just say, okay, this evidence shouldn't have been shown to the jury, so your conviction is voided, and because of the double jeopardy clause, we can't send you back for a second trial to show a jury not that evidence and have the lawyers argue. So you get to go free. And the reason why, and I'll talk, I'm not going to go into the reasoning in Mapp versus Ohio, but here's the reasons why. And then, from now on, there's this thing called the Exclusionary Rule. And that rule determines the operation of all of these courts. I mean, and really, the Exclusionary Rule is a trial court rule, so it really only dictates how things go in the district courts. But the Exclusionary Rule also then applies to how circuit courts and future Supreme Courts are going to analyze what goes on in these trials. So the Exclusionary Rule says that evidence that is obtained unconstitutionally cannot be used to obtain a conviction. So if somebody is convicted using evidence that is obtained unconstitutionally, that conviction has to be overturned. The Exclusionary Rule now is used by judges at the district court level when a prosecutor brings up some evidence and the defense attorney says, I move to exclude that evidence. Then there's a little mini argument within the broader case. The broader case is about guilt and innocence of the party. The mini argument within it between the prosecution and the defense attorney is, was that evidence obtained unconstitutionally or not? How does the judge decide? Because if the judge says, yep, that's unconstitutional evidence, you can't show it to the jury, then that's going to be harder to convict. Or if the judge says, nope, that evidence was not obtained unconstitutionally, so it gets shown to the jury and the conviction is going to be easier to get. How does that judge do it? Well, the judge looks back at Mapp versus Ohio and any subsequent case that has elaborated the exclusionary rule, and that's typically what happens. You get a policy-setting precedent, like Mapp versus Ohio, and then you get a set of follow-up precedents that elaborate on the boundaries of that new policy, right? But the exclusionary rule is the policy. It is now, in fact, Mapp versus Ohio it's a successful form of political reform. It changes how the political system functions. In this case, the system of trial courts, the criminal justice system. So it impacts the operation of our democratic system. Even though what's happening here is we don't have elections, democracy is more, I hope at this point you appreciate democracy, a democratic system is more than just elections and representatives. It is the entire operation of the way the government functions foundationally. The way trials go down is our political system. And part of the rules of evidence come from statute. There's a whole, if you go to law school, one of the first things you'll study is criminal procedure. You'll get a big fat textbook called Criminal Procedure, and a lot of criminal procedure is statutory law. It's things that have been set by Congress that are required steps. But then an awful lot of what's in that criminal procedure book is case law, which is another word for precedent, which is the exclusionary rule, which Congress never created the exclusionary rule. The exclusionary rule was created by the Supreme Court and further elaborated through a series of follow-up cases that took this policy and made it more specific. And that's actually one of the big differences between the statutory path and the constitutional path and the judiciary path, is that the policy-making process is usually incremental. In the sense that when you write a bill, or the executive branch creates a regulation, or there's a constitutional amendment, the entirety of the policy is contained in that statute or regulation or constitutional amendment. It doesn't mean that it can't be later amended or updated or added to, and sometimes it is and sometimes it isn't, but the policy in its entirety is contained in that piece of writing. Court rulings tend to start a policy with essentially a first draft, and it's that court doesn't write the whole policy. That court establishes a set of principles and standards and doctrines that guide future courts, often circuit courts, and not even the Supreme Court, but future Supreme Courts, in further and further elaborating. So the exclusionary rule is announced by Mapp versus Ohio, but it is far from completed as a policy by that singular case. There are several dozen important follow-ups that give us the boundaries of the exclusionary rule, that give greater and greater guidance to the judges at the district court level who are having to make this decision. There's two lawyers with evidence arguing, and the defense attorney saying it was unconstitutionally obtained, and the prosecutor saying no, it was constitutionally obtained. Even before that, there are police out there saying, okay, what can we do to gather evidence so that we can give it to the prosecutor and they can actually use it in a trial instead of having that evidence excluded. That policy that has created the contemporary version of the exclusionary rule, what isn't usable in court, what police can and can't do to gather evidence that will eventually end up in the hands of a jury, was elaborated incrementally over the course of a variety of rulings. But the foundational ruling, the original precedent, was Mapp versus Ohio. And that was an activist action. It changed the way things were done. Prior to Mapp versus Ohio, prosecutors could introduce evidence that was obtained unconstitutionally into a trial court. And you're like, well, how could they do that? The exclusionary rule is so familiar to us that it almost seems completely ridiculous to allow prosecutors to use unconstitutionally obtained evidence. But that was the practice beforehand, and Mapp versus Ohio created a policy. And that policy could have easily been created by statute as well. Congress could have said, here's the rules. When you get evidence that violated the Fourth Amendment, that evidence can't be shown. So things that are done through court rulings to the way the court system functions could be done through statute as well. Now, those statutes and any statute regulating the operation of any part of the government and the judicial branch itself is subject to judicial review. So if Congress passes a law about how trial cases have to go down, let's say that Congress passed a law that said that when evidence is obtained unconstitutionally, there must be a punishment for the police officer that obtained it unconstitutionally, but that evidence goes to the jury. And in fact, that's the argument against the exclusionary rule, which is essentially it's two wrongs, right? First wrong is the police violated the Constitution, and the second wrong is that a guilty person goes free because the actual evidence that showed that they really did commit the crime is kept out of the hands of the jury. Congress could pass a law that says that unconstitutionally obtained evidence results in a punishment, and it would specify the punishment in the statute, and results in the ability of prosecutors to show it to the jury. Then there could be a Supreme Court case judging the constitutionality of that particular statute. I hope that's not too complex or convoluted of a way of talking about this. But Mapp versus Ohio created a new procedure and it affected the way our criminal justice system functions, which is part of our overall democratic system. And so Mapp versus Ohio is a kind of political reform. If you wanted to get rid of the exclusionary rule, and people have since Mapp versus Ohio, for exactly the reason I just said, it seems to say, well, we're going to take a wrong and we're going to do another wrong to punish that wrong, and we're not even going to punish the police officer who does it, except by this sort of indirect psychological punishment that police officer has to now know that the criminal that they caught and found evidence that criminal gets to go free. There are plenty of people who are like, that's ridiculous. We need a political reform. In this case, it would be political reform asterisk or parentheses criminal justice version of political reform that changes that rule or procedure. So this is just one of innumerable ways that the court system itself is self-regulating, but only partially. As I say, statutes and the Constitution itself are part of the scheme that determines how our court system works, and court rulings are part of the scheme. And these are all traditional practices. The exclusionary rule is a traditional practice mandated by a court ruling, and the traditional practice that's behind that is that prosecutors and future judges abide by the rulings of the Supreme Court. Instead of saying, okay, well great, Mapp versus Ohio, Mapp got set free, the Supreme Court says the exclusionary rule works, but then there's a trial and the defense attorney says, I've moved to exclude this evidence that was unconstitutionally obtained. The judge could just say, Mapp versus Ohio, I don't care about that. That's just one case. That doesn't have any bearing on what we're doing here. The traditional practice of following precedent and having the Supreme Court rulings affect the entire judicial system into the future is the fundamental traditional practice. So the biggest one is precedent, otherwise known as stare decisis, which is Latin for let the decision stand. And what precedent means and why precedent is so important is that unlike the constitutional amendment avenue, which is essentially an intentional balancing of responsiveness and stability, precedent is stability written into the culture of our judicial system. And it's not governed by a constitution. The Constitution doesn't say judges have to follow precedent, that other political officers who are subject to these rulings have to follow precedent. It's just deeply embedded in our culture. And what precedent does is precedent says that stability and long-term expectations for what the legal system, how the legal system functions, are supremely important. But there's a little room for change and adaptation. So it also strikes a balance between responsiveness to the needs of contemporary society to do things differently and stability, but stability is the primary value underlying the whole mechanism of judicial reform. You have to build on precedent in order to make change. Now, that's not a rule, hard and fast. Sometimes the Supreme Court simply says precedent was wrong and we're just going to toss it. The most famous example of this, and there are only a handful of examples, but the most famous example of this is Brown versus Board of Education, which was a form of educational reform, and it was about equality fundamentally, which is not a form. It is kind of related to political reform. But Brown versus Board of Education simply said, Plessy versus Ferguson, which was ruled 60 years earlier, which said that you could have separate but equal facilities, and that would satisfy the 14th Amendment's requirement for equal protection of the law. Brown versus Board of Education simply said, nope, that was wrong, and this is the right way of looking at things. That is an overturning of an established precedent that itself had governed the educational system, the political system, the judicial system for 60 years. The notion that you could have a separate facility for different races as long as they were equal, and I'll air quote that because we know that they weren't equal, but that was the precedent. the court in 1954 simply said, that's wrong. So rare, because what the courts would usually do, and this is what we've seen with another important precedent, which is Roe versus Wade, is that in the incremental policy-making process, future courts, instead of just saying, Roe versus Wade was wrongly ruled, which some people, of course, want the Supreme Court to say, and there are at least a handful of people on the Supreme Court who are probably willing to do that. But what advocates of changing Roe versus Wade are really looking for is they're looking for an incremental development of a new precedent. And the reason why people want incremental developments of precedent instead of just an overturning like Brown versus Board of Education did is because precedent itself is stability. And the political system is intended to be responsive. That's what a democratic electoral system is. It is responsive to the will of the people. The people get to decide. Every 2 years, we get to throw out the entirety of the House of Representatives and bring in 435 new people. Every 2 years, we get to throw out a third of the Senate and bring in a new third. And of course, most of those people are reelected, but the democratic system, the political system, political questions are subject to a high level of responsiveness. The judicial branch and the judicial system, legal reasoning, is seen differently than political reasoning. In political reasoning, if the people want it, the people should get it. With some, like there's a balance, as I've said before, between responsiveness and stability. The legal system is seen as requiring stability because judges aren't supposed to respond to changes in public opinion. Judges aren't supposed to read public opinion polls. They're not supposed to worry about what voters think. They're not supposed to think about what would be popular, what would be acceptable to the majority of the American people, or the people of Oregon, or the people of whatever state you're in. They're supposed to say, what does the Constitution mean? And that is an ongoing, long-term conversation that is elaborated through the accrual of tens of thousands of cases. That case law precedent builds up the meaning of the Constitution. And if you want to move that in a different direction than it's gone, you can't just flip a switch and go the other direction. Whereas with a law, you pass the Voting Rights Act in 1965. 30 years later, you can just repeal the Voting Rights Act. Now, portions of the Voting Rights Act have been overturned by the Supreme Court, and most notably recently, but that's a pretty incremental process. The Supreme Court can't usually just get rid of an entire law, and it usually doesn't. But the idea that a law can be just changed, and the same thing with a constitution, a constitutional amendment can just change something, right? That's what an amendment does. Now, there's a high threshold for doing that change, but once an amendment is in place, the Constitution just means a different thing now, starting at this moment, right? When the 16th Amendment was passed, granting popular election of senators, Senate elections, the very next electoral cycle, were just different. There wasn't a gradual building up. There wasn't a slow process. The judicial branch proceeds in a more measured fashion. And that is generally pretty appropriate to the kind of foundational questions that the court is having to address. One of the things that we all know about Brown versus Board of Education is that while it did just completely flip an old precedent, it's a lesson in what happens when you do that and why that's generally not a good idea, which is there was massive resistance and there was significant disruption and there was just a giant level of conflict that resulted from Brown versus Board of Education. And Chief Justice Earl Warren, he knew that that was a possibility or a likelihood, and in fact, he insisted, we learned this later because most Supreme Court proceedings are completely secretive. We learned later that the reason why Brown versus Board of Education was a unanimous ruling is that Warren leaned on the he had a majority to pass Brown versus Board of Education, to make the ruling that he did. But he wanted a unanimous court because he knew that overturning an established precedent of any kind, particularly one that's so central to the racial divide in a large portion of the country, was going to be a major disruption. And it was going to be an anomaly in the world of legal reasoning because it was ignoring precedent. It was not only ignoring it, it was just flipping it 180 degrees. So he wanted a unanimous court to show the country that there was no doubt that this was the right way to go. One of the things about changing precedent in such a drastic way is that, and for example, the Supreme Court today just saying Roe versus Wade was wrongly ruled and there is no implied right for a woman to be able to terminate her pregnancy the way Roe versus Wade argued, that would create a lot of disruption, and things that were once constitutional are suddenly not constitutional. So the practice, and this is again a traditional practice, why does precedent evolve gradually? Why is change almost always incremental? Partly the Brown versus Board of Education example shows just why it is that flipping precedent is problematic and dangerous. The political system is supposed to be adaptive to changing public opinion and changing circumstances and changing policy problems. The legal system is supposed to be this bastion of stability and a long-term expectation that what the law is today is what the law will be in 10 years, is what the law will be in 20 years. That I'm not doing today something that's legal and then in two years it's going to be illegal, right? Maybe it will be because there's a statute that gets changed, right? Like today, if I'm required to give certain kind of health insurance to my employees, and then that law gets repealed, in 2 years I don't have to do that anymore, that's policy change, and we know to live with that. But if we don't know whether or not police are going to be able to search the trunk of our car and have that evidence be shown to a jury, if I don't know if that's going to change next week or in 2 years, then it's sort of too frightening. So stability is the primary value of our legal system. And it is actually a deeply acculturated value. Why does the judicial system actually continue to follow this path of very incremental change and of following precedent, sort of very slavishly? Because everybody who participates in this system has gone through law school, and law school is an intellectual boot camp that, among other things, deeply embeds the value of following precedent and not just of doing whatever you want, right? Like, oh yeah, we've got 5 people on the Supreme Court who want to rule one way, let's just go for it, right? Now, in terms of naked power and in terms of what the Constitution says or what statute law says, all it takes is 5 members of the Supreme Court to do anything that they want. But those 5 people and the 9 people who are on the Supreme Court have absorbed a culture whereby they don't just do that. That is disruptive. That's politics. And it's the same as the boundary here, or it's the same cultural values, the same cultural norms, culture within the judicial culture that produces this boundary. That some questions are justiciable and others are not. And the reason why some aren't is because we expect rapid change in the political system, or we at least acknowledge that it's possible. If a law gets passed, everything's different. If a law gets repealed, everything's different. That's an acceptable product of the political system. But there's this aura of difference between the judicial system, the judicial corner of our political system, and the electoral corner or sphere, right? And that is just purely traditional practice. Judicial review itself is a traditional practice. Pretty much the heart and soul of this avenue is upheld by what we can think of as cultural norms. Cultural norms being precedent is followed, the rule of law, that all laws apply the same to everybody, the future expectations that things won't change unless they change very slowly. And that's exactly how things go down. That's why court rulings contain all 3 of these aspects. Now, I want to say more about principles, standards, and doctrines, because this is where policy is made, and this is where policy is transmitted to the future and where incremental change happens. What does this look like? Well, what this usually looks like is a different kind of policy than we would get from a statute, where a statute actually lays out in great detail exactly what's supposed to happen. And not in such great detail that every circumstance can be anticipated. Even a 1,000-page bill is going to run into a need for interpretation later on down the line by an executive official who's charged with enforcing that or putting that program into action. There's definitely, even the biggest bill can't anticipate everything. But bills, statutes, tell an awful lot. What court rulings do, even a court ruling that's 100 pages or 200 pages, It's going to provide principled guidance, not specific details. And this is, again, a traditional practice, a cultural kind of norm, that when the court says, okay, here's the winner, here's why, and this is what needs to be done in the future, there's a self-enforced limit to what this can do. And what this is going to be is this is going to be guidance rather than specific determination. So, for example, the court doesn't say in Mapp versus Ohio, okay, here's what the boundary of the exclusionary rule looks like. Here are the types of activities that are constitutional, and here are the types that aren't. What it does is it gives guidance to future judges at the district court level, and then future Supreme Courts as they elaborate this, with a principle that doesn't have a ton of detail. Now, I'm going to switch to a different area of law to give an example of this, because I think that it will be made clearer this way. One of the most challenging features of the U.S. Constitution to interpret and apply is the Equal Protection Clause of the 14th Amendment. Probably one of the most important features of the Constitution, but also one of the trickiest, because what does it mean to be equal before the eyes of the law? And what happens when there are legal distinctions that seem to create inequality? Well, you might just say, sort of, off the top of your head, well, if there are legal distinctions that create inequality, that violates the 14th Amendment. The problem with that is that that's what laws do. Laws create distinctions. At the most basic level, a criminal law creates a distinction between somebody who broke that law and somebody who didn't. So equal protection law doesn't mean that everybody gets treated equally. Equal protection law means that, this is a more abstract concept, that everybody gets the same kind of treatment depending on what they did. So if you stole something, you go to jail. If you didn't steal something, you didn't go to jail. That's a form of inequality. That's an inequality of outcome. Whereas, all the people who didn't steal stuff don't go to jail, and then all the people who did go to jail, and they can't say, no, but the 14th Amendment says we have to be treated equally by the law. Treating people differently is a necessity in a legal system. That's what laws are. They're distinctions. So if treating people differently is built into the concept of a law, how do we treat people equally as we're treating them differently? That actually is kind of a mind-blown sort of question. The court, in interpreting the Equal Protection Clause, has to take on that very tricky question, because there need to be procedures put in place that allow courts to make distinctions but also to abide by the 14th Amendment. What the court has done is said, okay, there are distinctions that are necessary to a legal system. That's what a legal system is. It's a system of distinctions. But there are differences among distinctions. We can distinguish among different distinctions. And what we're going to do in order to apply the 14th Amendment's Equal Protection Clause is we're going to create levels of scrutiny for different types of distinctions. And different types of distinctions are going to get a different kind of treatment. Just as different actions get a different kind of treatment in the world. If you steal something, you get caught, you go to jail. If you didn't steal something, you don't go to jail. The court's saying we're gonna look at laws and government action the same way. And so the guidance here comes in the form of, in this case, a doctrine. And the doctrine is levels of scrutiny. Now, the levels of scrutiny are not like tax brackets that would come through a statutory act. Tax brackets are kind of a perfect example of something that's not guidance, it's specific detail. If your income falls in this range, you pay this tax rate. If it falls in this range, you pay this tax rate, etc. Levels of scrutiny is essentially guidance for future judges and prosecutors and appeals court judges and lawmakers to know that, okay, you're using a particular kind of distinction. Here's what's going to be used to evaluate that distinction. Originally, there were 2 levels of scrutiny, and then through the incremental development of this policy, there are now 3 levels of scrutiny. There's strict scrutiny, there's intermediate level scrutiny, and then there's what's called the rational review test. So there's not parallelism in the names, but it's a three-tiered system. So we have 3 tiers. And at each tier, there's a different set of principles that are applied to a law that is being evaluated. So the highest tier, strict scrutiny, applies to laws that make racial distinctions and that refer to fundamental values and makes religious distinctions or ethnic distinctions. So a law about race which has to do with race, is going to get strict scrutiny. And the strict scrutiny has a test, which is that the law, actually I'm probably not going to be able to say it perfectly clearly at this moment, but it's a 3-part test, which is that the law has to be narrowly tailored, there can't be a less restrictive method, and it has to be it has to serve a compelling government interest. What that means is this is all guidance, right? We have doctrine, which is the levels of scrutiny, and then we actually have standards within that, and those standards contain principles. That's why I say principles, standards, and doctrines. It's all kind of wrapped up. So here's a law that involves race, and of course, you know, in the old days, there were old days being the 1960s and 1970s. There were a lot of laws that had to do with race that were, you know, pretty clearly restrictive and racist, like, you know, anti-miscegenation laws, which is a law that prevents interracial marriage. Now, Virginia had a law barring interracial marriage, and that law was tested in a case that is now actually a movie called Loving, and the case was Loving versus Virginia. And the Supreme Court and the lower courts did the same thing. They said, okay, great, this is an equal protection challenge. And what the challengers are saying is that this clearly violates the Equal Protection Clause. And what the state of Virginia was saying was that no, we treat all races the same, which is that nobody, no matter what their race is, can marry somebody from a different race. So from the eyes, Virginia had an argument that the Equal Protection Clause was adhered to. And the Supreme Court says, okay, here's what we're going to do. We have 2 different views on this. Precedent has told us that we should be looking at this with the levels of scrutiny. This is an established way the court has adjudicated questions like this. And we're going to use the strict scrutiny test that comes from an earlier case, and we're going to ask those 3 questions. Is it narrowly tailored? Is there a least restrictive means of achieving the goal, and is it a compelling state interest? And in the case of Loving versus Virginia, the compelling state interest was rejected right away. The court said that the state does not have a compelling interest in deciding on the purity of the gene pool, essentially, because that's what was behind this. Now, the difference between a strict scrutiny question and a rational review question is that at the rational review level, the court would be asking a different set of questions. It would be applying a different test. Instead of a 3-part test, narrowly tailored, there's no lesser restrictive means, and it has to serve a compelling government interest. The rational review test is there a rational relationship between this law and the government interest? And is the government interest legitimate? Now, notice the difference between compelling and legitimate. It's clear that there's a difference there, but unlike tax brackets, which actually have a particular boundary, like, okay, if you make this much money, you pay this tax rate, and then if you make $1 more, you pay a higher tax rate. The difference between legitimate and compelling is guidance. It's more words, it's a concept. So what the court is doing is when it first announces a test, and then as that test gets developed, it is giving guidance, and then those tests are then applied in future cases. Now, what happened is originally there were 2 tiers, which was the strict scrutiny and the rational review, and what over the incremental use of levels of scrutiny happened was that intermediate scrutiny was added for laws that affected not race or religion or fundamental rights, but gender and sexuality questions. And so the intermediate review level has a different set of tests, and instead of having a compelling government interest or a legitimate one, it was an important government interest. So the levels of scrutiny actually were developed, further elaborated to take into account 3 different kinds of distinctions. Now, this is exactly how court rulings go. There's a winner, right? Loving one over Virginia. There's a reasoning, and the reasoning, the precedent, often comes from previous cases, announcements of principles and standards. And then there's also constitutional interpretation, which is, okay, what does the Equal Protection Clause mean? Where does this come from? This comes from having a particular kind of constitutional interpretation. I have to pause for a second here. Okay, so stop the tape there for a second, and now I'm back. I know this is ending up to be kind of a long lecture, and I hope that it's not too terribly much. But there's so much that's here. So I don't think I need to say more about strict scrutiny. It's not actually a question to do with political reform at all, but it's an exemplar of just what it is that happens when the judicial avenue of reform is used. This is the part that really matters. And this feeds future precedent. So when the court makes a ruling, it doesn't just declare a winner, and it doesn't just argue why that person is the winner. Like, okay, in Loving versus Virginia, Loving's the winner and Virginia loses, and the argument is why? Well, because in this case, there's already an established policy. Now, how do we get groundbreaking precedents? How do we get new precedents that set a whole new area of policy? Like, there was a first case where the levels of scrutiny were created. And usually, again, it's not super heavily determined in the very first case. Like Mapp versus Ohio started the exclusionary rule, but it didn't finish it. Actually, honestly, I should know this too if I'm going to use this as an example, but I forget what the first case that mentions the use of these levels of scrutiny is. But that's far from the end of the story. But how do we get that first groundbreaking case in the first place? It's here. Constitutional interpretation. Another very familiar and very important precedent, Roe versus Wade. There's no precedent to support an argument about reproductive rights or abortion because this is the very first case, and this is going to happen. It doesn't happen that often, and it happens less often because most area of constitutional law has been well trod, but it happens. There has to be a first precedent a lot of the time. Like Plessy versus Ferguson was the first time that the Equal Protection Clause was interpreted, and its interpretation that separate but equal facilities was acceptable then governed all the subsequent interpretations. Where did Plessy get that interpretation? Where did the court in Plessy versus Ferguson get that interpretation? Where did the court in Roe versus Wade get its interpretation or its precedent? When there's no precedent, there's how do you see the Constitution? And this is where judicial ideology comes into play. And I use the word ideology a little bit reluctantly, even though that's kind of the common way it's referred to, because it's not the same kind of ideology as a political ideology. Judicial ideology is really more of it's a literary interpretation style, right? Here's a written constitution, which does not include all of the detail that we need to take all of the actions that we're going to take. How do we interpret the Constitution to answer this plethora of specific questions that is bound to come up in any kind of government system? Same thing with statutes. Statutes are longer, right? A statute could be 1,000 pages, but there are still going to be questions that come up where you're like, well, it's ambiguous, or there are definitely two interpretations, and one interpretation says this thing is allowable, and another interpretation says that this thing is not allowable. Which direction do we go? This is where the judicial ideology, or probably the better term is judicial theory, comes into play, and this is where there is a difference between the judicial conservatives and judicial liberals. Now, I want to point out that there's a big difference between a political conservative or a political liberal and a judicial conservative and a judicial liberal. They do line up in certain ways, and typically conservatives, both judicial and political, are Republican, and liberals, both judicial and political, are Democrats. But a judicial liberal doesn't agree with a political liberal on all things. And the same thing is true for judicial conservatives and political conservatives. And judicial ideologies are more fixed than political ideologies because political ideologies are more responsive to changing times, right? What it means to be a judicial conservative hasn't really changed in 40 or 50 years. What it means to be a political conservative has changed several times in important ways over the course of that same 40 or 50 years. And this kind of harkens back to the justiciability versus political questions. The way that judges and justices and lawyers think through problems is with a different style of thought, a different style of argumentation, a different style of analysis and interpretation. What makes a judicial conservative is this. A judicial conservative is going to look at a constitution or a statute, and it's going to be reluctant to read too much meaning into the plain text of either that statute or that constitution. And what that means is that judicial conservatives will tend to be, as conservatives are overall, more deferential to the status quo, right? If a police department is interpreting the Equal Protection Clause or interpreting the Fourth Amendment's probable cause requirement in a particular way, then a judicial conservative is going to tend to say, that's fine, unless there's a really clear and plain piece of the Constitution, without digging too much, without reading between the lines too much, that shows that what that police department is doing is wrong. So, for example, one of the things that the Fourth Amendment requires is a warrant that particularly describes the person or places to be searched and the things to be seized. So that particular description has that's not that hard to interpret, right? What exactly goes into a particular description could be up to a difference of agreement, but if you have a search warrant that simply says, we're looking for evidence of wrongdoing by Jack Miller, that doesn't particularly describe the things that are to be searched and seized. And so even a judicial conservative is going to say, well, that interpretation is wrong, because the plain text of the Constitution, without digging into between the lines, without doing any kind of fancy interpretation, is going to be sufficient to tell me that that action is wrong. The other aspect of judicial conservatism is when you do have to do interpretation, when the plain text of the Constitution doesn't give a clear answer, and when you can't, when it's not available to you to just defer to the status quo as it's being enacted by the other branches of government, what you seek is the intention of the authors of that particular phrase of the Constitution. In the case of the Bill of Rights, you seek the original intention of the members of Congress who wrote and passed that and the states that ratified it. In the case of the 14th Amendment, which contains the Equal Protection Clause, you look, the founders of that amendment were the Reconstruction era Congress and the states that ratified it. So the originalist will say, okay, sometimes, like the phrase equal protection of the law, does require some interpretation. When we have to do that, we're going to point ourselves in a particular direction. Instead of allowing a more open-ended style of interpretation that brings into account both history and contemporary standards, we're going to focus historically. So conservatives, and this reflects the conservative bent in general, which is a deference to the status quo, a looking to the past for answers rather than looking to the present, and a kind of a general belief that a stable system of expectations is better for society than a changing one. And the opposite is what makes a judicial liberal. A judicial liberal is somebody who says, no, a constitution is it's a very open-ended document. It has certain specific things, but in order to take it from being a piece of paper into a living document, you have to dig. You're going to have to be doing a lot of reading between the lines. You're going to have to be doing a lot of interpreting. That's what happens. Same thing's true for statutes, though less, because statutes are longer. There will be fewer opportunities to have to do, or fewer requirements to do deep interpretation, but many cases will come up where that's the case. And a judicial liberal is then also comfortable not only reading between the lines more often, but using a mixture of concepts to do that reading between the lines. And one of the pieces of that mixture might be the original intent, but one of those pieces of that mixture is also contemporary standards. What does this mean, not just to the people who wrote it, but to people today? And so the concept of equality, as it was intended by the authors of the 14th Amendment, was really, in the context in which the 14th Amendment was written, the Reconstruction era United States, it really was about race. And if you went back in a time machine and said to the people in Congress who wrote this and who ratified it, what do you mean by this? They probably would have said, and the legislative record makes it pretty clear, that they really wanted to make sure that they were advancing racial equality. Now, a judicial liberal will say, okay, but by adding the concept of equal protection to the US Constitution, we're now actually putting this into our enduring political system. And so the founders don't necessarily get the last word on what this means. Maybe we should listen to them. I mean, we should definitely listen to them because it's important. But we also can listen to the subsequent generations who are living under a political regime that has equal protection as part of its processes. And so contemporary standards of what equality is about will play into it. So clearly, the authors of the 14th Amendment weren't trying to advance gender equality. In fact, they rejected, the very same people rejected the pleas of women's rights activists to make the 15th Amendment include not just racial restrictions, granting voting rights to black men, but gender distinctions as well, granting essentially voting rights to any adult citizen. They rejected that, and so it's clear from the historical record that, without even digging too deeply, that they were not interested in advancing gender equality. Judicial conservative is going to say, well, okay, that's what the 14th Amendment means. It's about racial equality. It can't be about gender equality because that's not what the original authors intended. A judicial liberal is going to say, why not? Why can't it come to mean, why can't the term equality, which is a very open-ended and difficult and philosophically squirrely concept to try to implement, why can't it come to mean more than it meant? Right? Clearly the authors of, this is jumping to a different set of case law, but clearly the authors of the Bill of Rights weren't thinking about protecting women's reproductive rights when they wrote the Bill of Rights. But why shouldn't we say that reproductive rights are actually part of what we look to the Bill of Rights to protect? And that's exactly what Roe versus Wade did. So what the precedent is, what the guidance and doctrines are, how they emerge will depend on constitutional interpretation to a large extent. And this is where the availability of the judicial avenue of reform for particular kinds of political reform is hemmed in not just by this boundary, the justiciability boundary, it definitely is, but it's also hemmed in by the constitutional theory of the majority of people who are on the court. Now, we hear an awful lot about, the conservative court and the conservative majority and the old liberal court and the old liberal majority. It's not as simple as saying, well, we've got 5 Republican appointees, so they're all judicial conservatives, and we've got 4 Democratic appointees, so they're all judicial liberals, and so the judicial conservatives have a majority, and they're going to win all the time, because there are different levels of judicial conservatism and judicial liberalism, and some justices who were appointed by Republicans are more conservative than others. And some justices appointed by Democrats are more liberal than others, just as people are different, have a different level of liberalism and conservatism in their political doctrines as well. The political spectrum is not 2 boxes, liberal and conservative, it is a spectrum. Judicial ideology is also a spectrum. And when you could say, okay, the conservative majority is, they agree on a lot of questions, and they do, right? But they don't agree on all of the questions that come up before them. So it's not simply enough to have a conservative or a liberal majority to make use of the judicial branch as an avenue of political reform. You also have to make an argument that creates a coalition of at least 5 justices who will agree with your interpretation. So what a political reformer doing? One, you have to find a justiciable question. And if the question that you have before you is in that gray area, as it was in Baker versus Carr, one of your argumentative tasks is to argue that this is a justiciable question. And that actually is a matter of constitutional interpretation as well. One of the things that the justices had to wrangle with in that case was, is this actually a justiciable question? Can this dispute be resolved through the judicial system instead of required to be resolved through the political system? And that has really almost nothing to do with specific party alignment. That has a lot to do with your constitutional interpretation and the separation of powers. And this was one of the key concepts that was at the core of the sort of the soul searching of the justices was, does ruling in this way, which seems totally fair, like harkening back to what I said earlier, no one was arguing that it was a fair democratic system that gave lots of voting power to people in these sparsely populated rural counties and virtually no voting power to people who lived in densely populated urban counties. No one said that fits democracy. The question was, do we as a court get to implement that standard? The one person, one vote is implied by a democracy, but where does that question get decided? And the reason why it was so harrowing is that it speaks to the question of the separation of powers, which is how much do you want the powers of the three branches to be separated? That's part of your constitutional interpretation, because the Constitution itself doesn't say. It sets, in fact, the Constitution itself doesn't use the term checks and balances. It doesn't use the term separation of powers. It doesn't use the term judicial review. There are a lot of things that our Constitution does not include at all that we think of as kind of foundational. Just an example, sort of totally out of the blue, a phrase that you would think is in the Constitution: innocent until proven guilty. That phrase, which is at the core of our criminal justice system, that when you're arrested and charged, you are innocent unless proven guilty beyond a reasonable doubt, none of those words are in the U.S. Constitution. That is a traditional practice built up and supported by court rulings. There's a lot of stuff that's not in the Constitution. Separation of powers, checks and balances, judicial review are big ones that are not there, but that they're clearly very important to how our Constitution functions, and they are extraordinarily important to how justices see the way they have to interpret different phrases. And so maintaining the traditional separation of powers between the judiciary and the elected branches, the executive and the legislature, was the core issue in Baker versus Carr. Once you got over the justiciability question, the rest was downhill, right? There was really no arguing that what Tennessee was doing was fair. And Tennessee itself only was arguing that you should leave it up to us to solve this problem. This was the argument, like you're getting into the political thicket. You're actually going to destabilize the current system of checks and balances and the current approach to separation of powers. Now, this is where judicial conservatism and liberalism comes into play, and different tolerances. If you're a judicial conservative, you might say, well, yeah, it's unfortunate that the court system can't be used to adjudicate a question as fundamental as voting power in this way. But that's the established system, and it's dangerous to set a precedent that changes that relationship, that destabilizes our system of checks and balances. And we've all, and essentially that's the way it's always been done, so let's continue doing things the way they've always been done. Tradition has proved that this is an enduring distinction and we should leave it well enough alone. A judicial liberal is not averse to saying, hey, times have changed and there is a new set of standards for looking at what democracy is, and there's an opportunity for us to reconceive of what the judiciary's role is, to move that boundary of what's justiciable. Because that boundary isn't set by the Constitution, that boundary is set by tradition. And there's no reason why we can't push tradition aside for something that makes sense. Because how are you going to change the voting system through the existing voting system, right? If the rules of how you get to be a representative are set by you, the representative, and those rules are clearly unfair, but we're going to rely on the elected representatives to change them, then we're not going to get change. So the judicial liberal is more comfortable saying we have to do something different. And that is, so the first question is, and in the case of Baker versus Carr, it was the first and it was pretty much the primary one, was the justiciability question. The second question then is, okay, once we've allowed that this is a justiciable issue, what direction does precedent take us in? What does precedent tell us? And there is an interplay between precedent and constitutional interpretation too, because you're at this point in case law with tens of thousands of cases, there's precedents that go in a lot of different directions. And that's actually what makes a good lawyer, and what makes particularly a good constitutional lawyer, is your ability to find the precedent that supports your side. Because the other side is going to have supporting precedent. And why precedent is problematic is that no two cases are exactly alike. And so when you're arguing from precedent, you're always arguing from analogy. You're saying, this case here in front of us, with specific nature to it, is very much like this other case that was ruled in this particular direction. So precedent is a ruling cultural norm in the legal and judicial world, but it is itself not unproblematic because the application of precedent is always a matter of judgment, right? And that's why judges are called judges, is because they're making judgment calls about the applicability of rules of procedure and the applicability of previously ruled cases. They're not making judgments about whether precedent matters or not. They're not saying, well, in this case, precedent doesn't matter at all. They're always going to be looking for which precedents matter. Part of your constitutional interpretation, too, is going to be, well, which of these past precedents are we going to lean most strongly on? And the difference between a justice who is a conservative and a justice who's liberal is that conservative justices will look at more narrowly ruled precedents, and justices who are liberal will look at more broadly ruled precedents and say these are the relevant and important ones. Roe versus Wade relies an awful lot on a case, Griswold versus Connecticut, which itself had a sort of liberal leaning to it, an open leaning to interpreting, in that case, a Connecticut law against the use of birth control. Very traditional act of state legislatures to regulate sexual practices. And in Griswold versus Connecticut, the liberal court majority there actually said, no, this strikes at a fundamental right of people to decide how they're going to regulate their lives. And even though we've been doing it this way for 150 years and allowing state legislatures to get away with this, times have changed and it's not acceptable anymore. And in fact, it probably wasn't acceptable 150 years ago, and just because we've been doing it for 150 years doesn't mean it's right. And then Griswold becomes a precedent that the advocates of Roe versus Wade say applies, because it has to do not with abortion, but with reproduction and the marital bond, as well as control over our bodies. And the opponents of Roe versus Wade say, no, Griswold, one, is not relevant, but two, it itself was poorly ruled, and it should be ignored, right? That's actually one of the things that does happen. Instead of overturning precedent tends to get, some of them get shoved aside and other ones get pulled in. And that is the way in which this incremental change happens. Okay, there's, I think, in a bottomless pit of stuff to talk about. And one of the things about this particular class is there are other classes in judicial politics, there are other classes in constitutional law and constitutional interpretation that would deepen this, in 10 and 20 weeks worth of material. So I feel compelled to tell you everything there is to know about this, but I think for the purposes of our political reform class, this is really all that you need to know. And I guess what that means is that I'm done lecturing for today. I'll see you, air quotes you, that is the camera, which is pointing me towards people, later this week when I do the next lecture, which is going to be on the interplay between statutory reform and judicial reform. So we're going to look at another very important case, Citizens United versus FEC, which shows the direct conflict between the political branches and the judicial system. So until next time, I hope that everybody is doing as well as possible under the extremely bizarre and unusual and uncertain circumstances that we're living in.